now.
Karan is not there. Karan? Nilesh, call Karan.
Good afternoon, everyone. During this entire COVID era, we have found that a lot of people are interested in framing their wills, unfortunately. However, what is the principal reason of framing a will is to ensure that there is no litigation. But often, the will is often found in various litigations. All the people who are left out or whose aspirations are not met, they reach court and the will often finds itself under challenge. Considering the importance of the issue in these times and also in the light of the recent judgment by Honorable Punjab and Haryana High Court, the team of informal webinars thought that we must have a session on the prerequisites of will, what you should do and what you should not do while framing a will. For that, we have a speaker, Mr. Vishal Aggarwal, who is a practicing lawyer in Punjab and Haryana High Court from last 16 years. He's an alumni of Department of Laws, Punjab University, and has been on panel of official liquidator and also various public sector undertakings and insurance companies. Mr. Vishal would be taking us to the various judicial decisions and the prerequisites for making a rock solid will. And over to Vishal.
Thank you, Karan. Good afternoon to everyone. As Karan has already introduced the topic for today, it is will. Though it may sound like just a 4-alphabet word, which is will, but believe me, it has so much around it, and especially in light of the recent judgment of the Honorable Punjab and Haryana High Court in the case of Maharaja Faridkot. So I'll take you through a PPT presentation. I must tell you that it's a very voluminous topic and very lengthy topic. So I'll have to little go fast. In case someone feels that I should slow down, I'll slow down. Otherwise, since we have a time limitation of about 1 hour, 1 hour, 15 minutes, the judgment runs into about 547 pages with about 300 pages devoted to the will itself. I'll have to little rush through. So please bear with me. But in case there is anything you want me to slow down, I'll do that. So I'll share my screen. If you could just all have a look at it. Yes. So the topic, as it says, is drafting of a will, right? Now, before I start, I must tell the basic everything about the will is given in Indian Succession Act. That act itself is so lengthy and so voluminous that if you start reading it, probably I'll need a lot of sessions to in fact complete it. So anyhow, I'll just point out a few important definitions in this. Will is defined in section 2, subsection H, which says will means the legal declaration of the intention of a testator with respect to his property which he desires to be carried into effect after his death. Thereafter, section 59, person capable of making wills. Every person of sound mind, not being a minor, may dispose of his property by will. Explanation, a married woman may dispose of by will of any property which she would alienate by her own act during her life. Explanation 2, persons who are deaf or dumb or blind are not thereby incapacitated for making a will if they are able to know what they do by it. Explanation 3, a person who is ordinarily insane, sorry, just a second, may make a will during interval in which he is of sound mind. Explanation 4, no person can make a will while he is in such a state of mind, whether arising from intoxication or from illness or from any other cause, that he does not know what he is doing. So the most important aspect, if you would have read this, the definitions, well, who can execute it? It says anyone can, but the most important they say is he must not be insane, must be sound, must not be intoxicated, and absolutely stable mind. So that is one of the very essentials. I'll be discussing it later also. Thereafter, there are two types of wills, privileged wills and unprivileged wills. Here we'll be talking only about an unprivileged will, which is defined in section 63, which says every testator not being a soldier employed in any expedition or engaged in actual warfare, or an airman so employed or engaged, or a mariner C shall execute his will according to the following rules. The testator shall sign or shall affix his mark to the will, or it shall be signed by some other person in his presence and by his direction. The signature or mark of the testator or the signature of the person signing for him shall be so placed that it shall appear that it was intended thereby to give effect to the writing as a will. The will shall be attested by 2 or more witnesses, each of whom has seen the testator sign or fix his mark to the will, or has been some other person sign the will in the presence and by the direction of the testator, or has received from the testator a personal acknowledgement of his signature or mark, or of the signature of such other person, and each of the witnesses shall sign the will in the presence of the testator, but it shall not be necessary that more than one witness be present at the same time, and no particular form of attestation shall be necessary. I'll just sum it up. It only says that the testator shall sign it. It shall be signed by 2 witnesses. It is very important that they sign in presence of each other. In case there is any exception, that is already mentioned over here, that how there can be an exception. But generally for a perfect will, it is very much necessary that the testator must sign the will in the presence of the witnesses, and vice versa, the witnesses must sign the will in the presence of the testator. Now, the section 74 talks about wording of will. It is not necessary that any technical words or terms of art be used in a will, but only that the wording of such that the intentions of the testator can be known therefrom. So, in other words, one should keep this will very simple in a very, very plain language. Do not use any complex language. Do not use any ambiguities. Try to make it that simple that even a layman could understand what is the intent of the will, what is the thought process of the testator. That is very, very important. We go on to this. Section 75 says inquiries to determine questions as to object or subject of will. For the purpose of determining questions as to what person or what property is denoted by any words used in a will, a court shall inquire into every material fact relating to the persons who claim to be interested under such will, the property which is claimed as the subject of disposition, the circumstances of the testator and of his family, and into every fact and knowledge of which may conduce to the right application of the words which the testator has used. As I already explained while discussing section 74, the court can go into the basic intent of the testator while drawing that will. What did he want? The accompanying circumstances as to when the will was drawn, what was his state of mind. Everything can be gone into by the court and make such necessary inquiries as to basically achieve the object which is mentioned in the will, the object which the testator wanted. So, as far the Indian Succession Act is concerned, I am only discussing these many sections. There are too many, there's more than 300, where it is defined how to draw a will, what are the ambiguities if there arise in the will, how are they to be interpreted. Everything is mentioned in this, but since today our topic is limited to the essentials of a will, and especially in the light of the judgment, I'll remain confined to that. Now, Quadi Proving the Will, Indian Evidence Act 1872, section 68 says, proof of execution of document required by law to be attested. If a document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has been called for the purpose of proving its execution. If there be an attesting witness alive and subject to the process of the court and capable of giving evidence, provided that it shall not be necessary to call an attesting witness in proof of the execution of any document, not being a will which has been registered in accordance with the provisions of the Indian Registration Act, unless its execution by the person by whom it purports to have been executed is specifically denied. Now, what it says is that it is necessary to call an attesting witness into the witness box to depose about the will. Now, the aspect which comes out here is whether registration of will is compulsory, mandatory or not. We cannot say it is mandatory, but it must be got registered, because then the authenticity attached to it definitely increases. If there is a registered will and there is no opposition to it, and if it is admitted by him, then there is no requirement of proving it as well. However, if it is unregistered, even if it is proved, then also you would be requiring one attesting witness to prove it. Section 68 talks that if this document requires registration and if it is opposed, then at least one attesting witness has to come to depose about the will and to prove it. So that's section 68. Now I'll straight away take you as to what are the important minds one should keep in mind while drafting the will. Please go through it very carefully. These are very important, but they cannot be exhaustive. Name and details of the testator along with exact age. When you mention the name, please do mention the correct name. If there is any other name, alias, etc. Details, the address, and the age as per some official document. Suppose someone says, my age is 80 years as per my Aadhaar card. So if you refer to that, there shall be no dispute regarding the age, because that is one of the suspicious circumstances which arises. Name of all the legal heirs of the testator. If a client comes to you, you must take the name of all the legal heirs of the testator, all the children, wife, irrespective of the fact to whom the testator wants his property should go. I must say over here is, will is always an exception to the natural succession. Generally, it says is, if the basic requirement of the will is, when you want that your property should go to a particular person, it should not go to a particular person. So an exception to a natural succession. When it is an exception to a natural succession, it becomes all the more important that you name all the legal heirs of the testator in the will. You mention why the following legal heir is being given this property, why the following is not being given in absolutely clear words. So details of all immovable and movable properties of the testator must be mentioned. The manner in which the testator wants the same to be distributed after his/her death, that has to be specified. The reason for distribution of the property, especially when some legal heir has been excluded from the will, I've already discussed above. You must give that reason. That so, and I have 3 sons, but my youngest son is taking care of me, so I want to give him this. My elder son does not take care of me. My middle son, the second son, he is very well off. He does not require it. Specify all these things, then only you cover up everything. Then it says, preferably specify the movable and immovable properties separately, and even its distribution should be mentioned separately as per the desire of the testator. There are differences. The testator always want that movable should go in a certain manner and immovable should go in a certain manner. It is desired that you specify, make separate heads, that these are the immovable properties owned by the testator. These are the movable properties owned by the testator. The immovable properties shall go in this manner. The movable properties shall go in this manner. That is to remove any ambiguity in it. Then you must mention whether it is a first will or not. If it is not the first will, then the details of earlier will must be mentioned and reasons should be given as to why it is being revoked. Point 8 must mention that the testator is in sound mind and doing it on his own free will and without any pressure or coercion. I'd already read the Indian Succession Act. That itself provides that the testator must be in sound mind, must not be intoxicated, must not be under the influence of anyone. That aspect must be mentioned. There are a lot of judgments to state where it was not mentioned. That means there is something wrong. It is not specified that the testator was in sound mind and he had executed this will without any pressure or coercion. Then you must mention that the same has been read over and explained. Thereafter, you must mention that in case of any addition to the property or deletion, then as to how it shall be distributed. It is quite possible that after the execution of the will, the testator may sell some, may add some property. There can be addition to movable properties also. So you must make a provision for that in case something is added to the movable property, it shall go in this manner. In case anything is added to the immovable property, then it shall go in the said manner. Must mention that the testator has signed it in presence of the witnesses who have signed as witness in the presence of the testator. So you must mention that this will has been signed by the testator in the presence of witnesses and they have also signed in its presence. The testator and witnesses must sign in each other's presence. Generally avoid the witness being any beneficiary or its close relative. So, presuming the testator is giving his property, most of it to one of the son, you should avoid the son or any of his close relative, including the wife and etc., to be a witness to it. Not that it is barred, but then the heavy onus lies on the propounder of the will. If the said person, that beneficiary, becomes the witness to the said will, the onus on him to prove the will become very heavy, and it will become very difficult if the will is challenged in the court of law. Preferably write the name of the person drafting the will. That will always help you as an additional witness as well, who can always depose that in case the will is challenged, that the testator had come to me and was absolutely sound mind, dictated these things to me. I've drafted it, typed it. That will definitely help you. Registration, as I said, though not compulsory, but preferably must be got done. It definitely helps you a lot. And above all, keep the language simple, unambiguous, but without missing out on the maximum possible details. Avoid cuttings in the will. So that actually completes it. I'll just sum it up. When you make a will, be very sure of it. The testator comes to your office. You've drafted it. The test in your presence, it is suggested it in your presence. The testator must sign it, and the witnesses must be present when the testator signs it. When the witnesses signed it, the testator must be present. So they must sign in each other. I'll tell you the reason for it. When the will is challenged and the witness is examined, he is bound to forget as to what happened that day. A photographic memory of a person is much better than what you try to explain him or what you try to tell him to learn. So he would always remember that on that day, it was sunny afternoon at about 12 p.m. when the testator was sitting. He signed it in my presence, I signed it in their presence, and that would definitely help you in proving the will. Generally, people draft the will, give it to the testator signs it at his home, he sends it to one of the witnesses, he signs it there. Then when they go to register, the second witness signs it over there. When the time comes, when the will is challenged and the witness is to depose, he is bound to forget it. You will ask him, did he sign in presence? He'll say, yes. Where were you? He'll say, one of them will say that we signed it in the registrar office. The other one will say we signed it in the office of the advocate. And the deed writer might say that no, he signed it in my office. So 3 different versions, and the 4th one of someone else witness also. Meaning thereby, the original, the proper will has also got defeated. The very purpose of doing it gets defeated. And then, as I've said, keep the language very simple, very straight. Do not mix up. Do not try to use complex language. We are not here to show our vocabulary over here. Keep it so simple that even if the testator wants to read it, can understand it as well. The third part, which is very important, is do not have any cuttings in the will. Do not hesitate to take 20 printouts 20 times if need be. If the changes are to be made as many times as possible, you should take a fresh printout. Just tear off the earlier will, but make no cuttings. Every cutting is a suspicious circumstance which definitely would lead to defeating the very purpose of executing the will. The judgments on this point are plenty. I have only referred to about 2 of them because the basic content and the basic emphasis will be on the judgment. There is one, this Savitri and others versus Kathyani, where legal requirements are mentioned, which it says that it has to be proved in terms of the Indian Succession Act. The onus of proving the will is on the propounder, as I already told you, that if the propounder should not sign the will as a witness, preferably, because a lot of onus is on him. Then the execution of the will by the testator has to be proved by at least one attesting witness. Then it is required to be shown that the will has been signed by the testator with his free will, and that at the relevant time he was in sound disposing state of mind and understood the nature and effect of the disposition. As I already said, judgment also says so. It is also required to be established that he has signed the will in the presence of 2 witnesses who attested his signature in his presence or in the presence of each other, as I have already stated. Only when there exist suspicious circumstances, the onus would be on the propounder to explain them to the satisfaction of the court before it can be accepted as genuine. I just missed the slide. Court must satisfy its conscience before its genuineness is accepted, but what is necessary thereafter is a rational approach. So this completes this judgment. There's another one. You can just have a note of it. Bharpur Singh versus Shamsher Singh. I've given the details. I'll pass on this compilation, where the Indian Evidence Act section 63 proof of will is discussed. Suspicious circumstances shrouded in execution of will given below. Court should consider these circumstances before granting probate. The signature of the testator may be very shaky and doubtful or not appear to be his usual signature. The condition of the testator's mind may be feeble and debilitated at the relevant time. The dispossession may be unnatural, improbable, or unfair in the light of relevant circumstances, like exclusion of or absence of adequate provision for the natural heirs without any reason. So as I already stated above, you must make a mention of all the legal heirs and give the reason as to why a particular legal heir is being given the property and the other is not. That's exactly what this judgment is saying. The dispositions may not appear to be the result of testator's free will and mind. I'll discuss this while we discuss this judgment. The court can very well interpret that to see whether the testator was in a free will and mind or not while executing the will. The propounder takes a prominent part in the execution of the will. The testator used to sign blank papers, something very important. The will did not see the light of the day for long. Incorrect recitals of essential facts. These circumstances are not exhaustive. As I already said, these are not exhaustive, but there's a lot to go. Now here, I am almost finished with the essentials of the will, wherein I've already discussed that what all you should keep in mind. But as I have already said, that the suspicious circumstances and all these things are not exhaustive. And especially after reading this judgment, you will find as to what are the intricacies involved, till what stage the court can go to determine whether the will is genuine or not. That is something actually marvelous, which every one of you must read. It's essentials of a will in light of the will of Maharaja Faridkot in judgment so and so, which I've already mentioned. Now, this pedigree table is a must, which you must understand. All of you, please, all your eyes on this pedigree table to understand this. And you'll probably have to, you can even take a photograph on your mobile so that you remember when I say the names. Originally, Maharaja Brijinder Singh Brad was the Raja of Faridkot, and he had a wife, Maharani Mohinder Kaur. I am specifically stating so because this would be relevant. He had two sons, that is Raja Harinder Singh Brad and Kanwar Manjeet Inder Singh. Now here we would be concerned with Raja Harinder Singh Brad, who was the last known ruler of Faridkot, that is Maharaja Faridkot. Being the eldest son, he was the one who became Maharaja Faridkot in about 1918 when Maharaja Brijinder Singh Brad died. Now Raja Harinder Singh Brad had one wife, that is Rani Narinder Kaur, three daughters, the eldest one being Rajkumari Amrit Kaur, the middle one Rajkumari Dipinder Kaur, and the youngest one Rajkumari Mahepender Kaur. Then he had a son, Tikka Harmohinder Singh. Now, unfortunately, Tikka Harmohinder Singh, the only son of the Raja, died in the year 1981 before he executed the will in 1982. So at the time of execution of this will, that is in 1982, what we must remember is he had three daughters, one wife, and a mother alive in 1982. I repeat, he had a wife, a mother, and three daughters. Son had already died. Now let's go to little facts to know what is this. I've already said the will is 1st of June 1982, which was allegedly executed by the Raja. He was alive. 1610. Now these dates would be very, very important because they find a lot of mention in the judgment, and each and every day is making a lot of difference. 16th of October 1989 is when Raja Harinder Singh Brad dies in Batra Hospital in Delhi. 17th October 1989, he was cremated in Faridkot. 20th October 1989, Board of Trustees and Executors assembled in Moti Mahal, Kila Mubarak, Faridkot, where Sardar Umrao Singh Dhaliwal read over the contents of the will. How the will was discovered, I'll discuss it in future when we go further, because that will be very, very relevant. Now the will, what are the highlights of the will? If you want to have a look at the will, I can give you a look at the will as well, though it is not a very clear copy, but still I'll try to show you how the will looks like. I've been able to get a copy. This is the will. It runs over 9 pages. This is how the will is typed. If you could just see that it is typed, and very neatly typed though, but I'll tell you what has happened thereafter. Every page is signed by the Maharaja. I'll take you till the last page. Every page and very neatly written. You must understand that 3 copies of the wills were made, 2 in English, 1 in Punjabi as translation. All 3 were signed by the Maharaja and duly registered in the office of sub-registrar, where it was pasted as in register. So this is the will of the Maharaja. This is the last page. If you see Colonel Sir Harinder Singh Brad, that is the Maharaja who has signed it with 2 witnesses, and that's how the will is. That's the will we talk about, the 20,000 crore rupees will. So now I'd come back to my uh, highlights of the will. The will, it starts with the details about the family, wherein the Raja states that he got married and he has 3 daughters. Son has already died. Now there, everyone knew that 1981, the son of the Raja had died. 1982 is the will. He was in very bad shape, they say, and he was not in sound mind, not very good sound mind. So in that, he stated that in case a male child is born to him, then all the property shall be inherited by him. That's the thing he first wrote. And however, if a female child was born, then he provided a flat in New Delhi, Hyderabad, or Chandigarh, either one of them, and rupees 25,000 per annum as maintenance allowance for life. She be provided a moped at the age of 14 years, scooter at the age of 16, and Indian-made car at the age of 18 years. Rupees 50,000 was provided for her marriage. That's the provision of this. Then he further stated, in case no male child was born, as referred above, subject to the female child being born, the entire property shall be inherited by a trust known as Maharwal Khewaji Trust, comprising of board of trustees with Badhurani Dipinder Kaur, that's the middle daughter, as chairperson, and Rajkumani Mahipinder Kaur as vice chairperson. She is the youngest daughter. Other members of the trust were also provided. I'm not discussing here. That is in page 28216 of the judgment. Now, Sardar Umrao Singh Dhaliwal, who read over the will on 20th of October when the Raja had died, was appointed as the chief executive of the board of trustees. A board of executors was also made for execution of the will. Rajkumari Mahipinder Kaur was to be provided a suitable residential. She is the daughter, the youngest daughter. A suitable residential accommodation for her lifetime. Wife, Her Highness Rani Narinder Kaur Sahiba, was to be paid rupees 36,000 per annum, and possession of Faridkot House, New Delhi, for her personal residential use during her lifetime. That's the only provision made. So she was to get only 36,000 rupees per annum and this house to stay. Provision was made for salary to the members of board of trustees as well as board of directors. Income of the trust was to be used for the maintenance of the properties and preserving historical monuments. Some amount was payable to the daughters out of the trust income at Grindlays, UK. The Raja had made the trust at UK also, Grindlays, where the income was distributed to the daughters. Originally, it was to half of it to 3 daughters and half of it to the son. However, since the son had died, so it went to the daughters. Then the will was duly signed by a testator and 2 witnesses. It was registered as well with the registrar, wherein 2 copies were typed in English and 1 in Punjabi, which formed part of the will, being its translation. Thereafter, Rajkumari Amrit Kaur challenged, that is the eldest daughter, challenged the said will along with claims as put forth in the suit filed by her in the 1992. There were 3 suits filed, in fact, the other one by the other daughter as well as by the brother of the Maharaja as well. Then the learned courts below held the will to be invalid and partly allowed the suit. Parties to the list filed the appeals, which 2 stands dismissed, upholding the order of the learned courts below. Now here I am pointing out the arguments put forth by the defendants, including the trust, for the validity of the will and support of the will. If you read this, in fact, and if you read the judgment, you will find out that it looks like a perfect will. Whatever I have stated above, that what all the will should have, you will actually find it over here. The will is duly typed, signed by testator on every page, claiming it to be a holograph will. A holograph will is which is typed by him himself, by the testator itself, that is the Raja. He's written it over there and witnessed by 2 witnesses. Further, the sub-registrar, upon presentation of the will, did necessary compliance and it was duly registered and has given a certificate. The sub-registrar has recorded the time, place, and date of the execution and given a certificate to this effect. The testator died after 7 years. The brother died in 1989, but took no steps to cancel the same. Will has been produced and proved in many courts and judgments. There were a lot of litigation. There also there was a reference to will, but nothing challenged. The Raja established many trusts after the said will, where will is referred to. The said trust bears the signature of plaintiff. The Raja from the year 1987 to 1989, in fact, established 3 trusts for different purposes. In that also, there is a little passing references of the will. So it says that the will was pretty genuine. Then the attesting witness Prajinder Pal Singh was duly examined. Will in original with second original will and Punjabi translated copy bears the signatures of the testator at 33 places. So you can well imagine that at 33 places it was signed by the testator. The signatures as such were not disputed, because even in the suit filed by the eldest daughter, she did not as such dispute the signatures. She says it could be under influence or something has been misused, but she did not say it is not the signatures of her father or the Raja. Then Sardar Umrao Singh Dhaliwal was close to the Raja and was conferred with titles as well as CEO of trust created under the will. Now he was the one who discovered the will, who read it over. He was the CEO. So there was nothing doubtful. They say it's absolutely fine because Sardar Umrao Singh Dhaliwal was pretty close. He was conferred title by the Raja in 1965. So everything was perfect. Then the adequate provisions were made for the family members of the will. The name of the plaintiff was excluded as she had married against the wishes of the Raja in the 1951, and in the 1952 the Raja in his another will had excluded her. So they also tried to explain this. The plaintiff herein, the eldest daughter, had got married against the wishes of the Raja in the year 1951. There was a will of Raja in 1950, and thereafter he made another will in 1952, stating that this daughter of his has married against his wishes, so he doesn't want to give anything to her. So they say that's pretty novel. She was excluded for the very reason that she had married against the wishes. There's nothing wrong in this. So that's how it is. Then it was stated there is no evidence of any undue influence, fraud, or misrepresentation. The executors have not derived any benefit from the will. I'm sorry, point 10, I must restate. When this suit was filed by the eldest daughter, she in fact had actually no idea as to what is the influence, fraud, or misrepresentation in the will. So in the suit, there are no details of any fraud. She simply states that this will is invalid. It's because of some influence, fraud, or misrepresentation. Nothing is explained. In fact, this entire thing as to what happened, the fraud, the influence, misrepresentation, all was discovered when exhaustive evidence was led over a period of decades, in fact, not years, but decades. So that's how it says. The executors have not derived any benefit from the will. Signatures of testator got examined by handwriting expert and proved to be his only. The trust produced the report of a handwriting expert saying that the signatures on the will, the 33 signatures on the will, belong to the testator, that is Maharaja Faridkot itself, and therefore there is nothing doubtful. Then the copy of the will was handed over to the plaintiff on 26th October 1989, which was opened and declared in mass gathering on 20th October 1989. Now just imagine that the Raja dies on 16th, 17th, he is cremated. 20th, the will is discovered, which is pretty natural. 3 days is not much of time, and it's perfect timing, I would say. It is read over. And 26th October 89, the copy was given to the plaintiff, meaning thereby there was no scope of any manufacturing of the will or forging of the will, and it was portrayed that it's as it went very naturally. Then it says that the mother of the Raja was not given any share because he did not expect that she would survive her. Therefore, no provision was made. Will accepted by other daughters, though challenged at a very later stage by the youngest daughter. Now, the middle daughter became the chairman of the trust, and the youngest daughter became vice chairman. So they never challenged it. Of course, in 1997, the youngest daughter challenged it. That was quite late in the day. But before any decision could come, she died in the year 2001 or 2, and the suit was dismissed in default. So the argument put forth was it was definitely accepted by the daughters. And then the delay in challenging the will. There is a delay in challenging the will. The plaintiff had put forth many arguments with evidence challenging the will and explaining the suspicious circumstances sufficient to hold it invalid. I am not going on that as to what are the arguments, because I'll straight away go to the findings of the court over here. Now, I'll just screen. If you could just unmute for 2 minutes, everyone. If you would have actually seen this, whatever I have stated in about the will, if I am not wrong, subject to any difference of opinion from anyone, the will looks to be pretty perfect. It is typed, it is signed by the testator at 33 places. It is duly attested, it is duly registered by the sub-registrar. The attesting witness has duly deposed. The will, there is no delay in discovery of the will. 16th, the Raja died. 17th, he was cremated, and 20th the will was there. The trust duly took over. The middle daughter was the chairman. The younger daughter was the vice chairman. The elder daughter was excluded because she had got married against the will of the Raja. The wife was given due share. The mother, he never thought would survive her and had his own property. So to me, at least it looks like that the will was pretty perfect. There was nothing wrong in it, and it could have actually survived. But when the arguments began, when the evidence was led, you'd be actually survived to see, you'd be actually surprised to see as to what happened. Does anyone have any question over here or anything you want to ask? I can proceed further now. Should I proceed further?
Vishalji, there are two questions as of now. One is asked by Padamji. He's asking in reference to section 63C, where it says that while it is, of course, it is provided that the testator and the witness should sign in each other's presence, but it also talks, 63C also talks about on the directions of the testator.
Yes, exceptions are there. Exception is definitely there, that in case there is some a circumstance which arises where it cannot be signed, then it can be done in the absence also, where directions, where the testator can direct that you please sign it. I have signed it. Assurance. It's like given an assurance. But when the issue of evidence comes, then it creates a problem. Because I have already reproduced the judgments. The courts have always said that it is not mandatory, but generally to remove any suspicious circumstance, the testator must sign in presence of witnesses, and the witnesses must sign in the presence of testator. How would you ensure that the testator was on free will? It is with his own consent, without any pressure, without any coercion. If it is a sign, presuming he's under some distress or maybe under some threat. Suppose one of the sons of the testator is holding him back, that you better tell him that you've signed it without any pressure, and you sign it. That will happen. But if it is signed in presence, there is every possibility of it being discovered whether there is any pressure or coercion, and it's on free will on mine.
All right. Then the next question has come from Suvir Ji. He's asking a little deliberation on the aspect of rule of primogeniture.
Rule of primogeniture, I am not dealing with it today, but I'll still tell you what it is there. Now, there were two aspects to it. The eldest daughter had also claimed claim her right to this property on the rule of primogeniture, and so was another suit filed by the brother of the Raja also, citing the same rule of primogeniture. Primogeniture means that the eldest would succeed to the entire property. Now, there are two aspects. The brother of the Raja said that the eldest of the male child would succeed to the property, while the daughter said the eldest of the child would succeed to the property. So that dispute definitely remains, that whether that rule of primogeniture would lead to the being eldest male child or eldest daughter. Though I must tell you over here, in this particular case, there are two aspects which have been dealt by the Honorable Court, saying when this situation had arisen wherein the son of the Raja had died, the eldest daughter, that is the plaintiff itself, had applied for her share in the income from the Grindlays Bank, the trust at Grindlays in UK, on the rule of primogeniture. The bank at that time had taken reference from the courts as well as over there and held it to be in favor of the daughter, saying that yes, rule of primogeniture would apply and she would be entitled to the income, and it was started over there. But when this aspect came over here before this honorable court, this honorable court dismissed the claims both of the eldest daughter as well as the brother, saying that the rule of primogeniture is just a custom which is no more valid. After the PEPSU had merged, this rule of primogeniture, a custom, is not valid. It has to go as per the lines of succession or as per the will. So that is primogeniture.
I think so far only as many questions are there. Vishal, you can continue.
Okay. So having said so, now I have already read out what the will was and how ultimately what are the findings of the honorable courts, and you'll be surprised to read it. The first aspect is about the custody of the will. As I already stated earlier, it was alleged that Sardar Umrao Singh Dhaliwal brought the same from the safe of the deceased Raja. After his death, it was claimed to be with Lal Singh Sarai, and ultimately the same was produced by Lalit Mohan Gupta, CEO of the trust. In spite of the court having issued directions in 94, the original will was produced in the court in 2012 after the plaintiff evidence was over. So you can well imagine how the trust functioned. In 94, the plaintiff had filed an application that the original will must be produced in the court. The court issued direction that yes, it should be produced. Still, this will was produced almost after 20 years in the year 2012, when the plaintiff evidence was over and was on the rebuttal stage. So that in itself court considered to be something, a very suspicious circumstance. Now, in continuation to as to how the will was actually discovered. Now, Sardar Umrao Singh Dhaliwal said that I had the keys to the safe of the Raja in Faridkot. And after the death of the Raja on 20th of October, I opened the safe and got the will. Now, the court held that it is very unusual that the Raja, while dying, did not tell any of his family members, his wife, his daughters, anyone about the said will. He did not hand over the keys of the safe to him, that keys of the safe which was operated only by the Raja. And why he should have given it to Umrao Singh Dhaliwal is something very suspicious and does not appeal to the mind of the court at all. And then something very interesting happened. They say, whatever you may do, you ultimately leave some evidence behind. Now, 16th Raja died, 17th he was cremated. The will was opened on 20th. So before 20th, there was no question of knowing as to what is there in the will. Sardar Umrao Singh Dhaliwal was not the witness to the will. He did not know the contents of the will. As per the daughters, they did not know the contents of the will. There was no one knew that whether a trust is being formed or to whom it is going. However, on 17th October, the day Raja was cremated, Sardar Umrao Singh Dhaliwal, along with the middle daughter, who was to become the chairman, they took declarations from all the employees of the Raja that they are henceforth the employees of the trust. So the court says, how did they know on 17th October that this will is going to be, in this will, a trust is going to be formed, which in itself shows that there is a forgery. They already knew the will and they had forged it. Then thereafter, DW1 was Brajinder Pal Singh, the attesting witness of the will, who in his 5 times in his cross-examination stated that there are only 2 copies of the will. But when he was confronted with the register of the sub-registrar which was brought in the court, he changed his version. He says, no, there are 3 wills. I've already told you earlier, there were 2 copies of the will and both of them were typed separately. They are not the carbon copies, both of them typed separately. And then a Punjabi translation of the will also, which was also signed by the testator and got registered with the sub-registrar. So, sorry, the same thing that if the will has not been signed in presence of the testator has not signed in presence of witnesses, there's hanky-panky, you are bound to forget what has happened. You cannot remember. He forgot there were 3 copies. He only remembered there were 2 copies. And he throughout 5 times he said 2 copies. Only when that was produced, he says it was 3 copies. So that was suspicious circumstances. The court says a very valid suspicious circumstances. Then something very surprising. It was said that all the 3 wills were typed on the same day and signed on the same day and typed by the Raja, being a holograph will. But there was no explanation as to why the date was handwritten on the wills in English while it was typed in Punjabi. There was absolutely no explanation. In the will in the English, the date was written with a pen, while in Punjabi it was typed. The court says it is very, very clear they are not made on the same day and they are made by at different times. Then the witness, he stated that he had never signed on the blank page, which was proved to be false from the register of the registrar. In the registrar, in the Punjabi will on the last page, there were signatures on the blank page. So the witness himself forgot that he had signed on the blank page itself. And as a matter of routine, being an advocate and all, he just said, no, I have never signed on the blank page, forgetting it is there. After seeing the register, he of course admitted it. So we could all imagine that how the testimony of the witness just got eroded with so many contradictions. Then the witness was asked something very funny, that whether the will was typed on typewriter or computer. He says, I don't know whether it was typed on a typewriter or computer, forgetting that in fact in 1982 there was no computer at all. It could have only be typed on a typewriter. When he saw the will, he says, no, yes, I remember now it was typed on a typewriter. Then he did not even know about the type of paper used. there was a very special paper used with a sun watermark on it, which the Raja had used. Then he stated that there are no cuttings on the will, when of course there were many cuttings. He was also asked whether you know that the sub-registrar took away the copies of the will or it remained there. He says, no, I don't know whether he took away or not. So again, that aspect, this will, I must point out over here, was registered between 5 p.m. to 6 p.m. at the house of the Raja itself, as told by them, and the registrar. Could you mute, please? And it was stated that the registrar had come to the house of the Raja.
Facebook पे लगा ले, on है Facebook पे.
Karan, can you just mute them? Karan, can you mute them, please? So it was registered between 5 p.m. to 6 p.m. 5 p.m. to 6 p.m. in the evening at the house of the Raja. There was no explanation why he came there and whether the sub-registrar took away the wills or left it to be there after attestation. So he forgot that also. Then the most important aspect was the plaintiff, after the original will was produced in the year 2012, sought permission of the court that the handwriting expert is be permitted to take the photographs of the will and compare it. So that was allowed. The handwriting expert was Dr. Jessie Anand, who gave her report in which it was discovered that in fact the type matter overlapped the signatures of the testator. That was like a final nail in the coffin, which proved that the blank papers of the Raja had been misused and the matter typed over it. There were dots and O's over the signature of the wills, to which the trust could not explain as to trust, or even the daughters could not explain how this has happened. So what I am trying to show over here is that up to what extent the court went to see as to whether the testator had really signed the will or not. And these are the issues which have been covered, and it's not the end, it's more Abhi. Then there were, while typing was done, they were seen that in the Punjabi will, the words were shortened at the end to accommodate in the same paper. So that's a very common mistake which are made when the will is typed on or written on a blank paper. It is not possible to know as to how many lines would one be writing. So at the end of it, one tries to shorten it to finish it. That's suspicious circumstance, of course. Then a very important aspect was from where things really went haywire were that pages number 41 to 60 from the register of the sub-registrar were torn, while those prior and later were intact. Moreover, there was no page numbering on page number 41 where the will was pasted while it was there on all others. It couldn't have been worse. This register had over 100 pages. Page number 1 to 40 were page number 1 to 27 were intact, and then from 61 onwards were also intact. But when the original register was called in the court by the plaintiff, pages number 41 to 60 were all torn. Sorry, actually it's 27 to 60. It's wrongly written. It's 27 to 60 were torn, totally torn. And all page numbers were printed. The page numbers were printed on the pages, but on the page number 41, where the will was pasted, there was no page numbering. See, the court said this is very clear that this has all been done later on. You've torn the pages to destroy the evidence. You've used another page. This will has been made later on. You've pasted it over there at page number 41, which is very clear from this. So you can just imagine how it has gone. Then something very important, page 10, which generally we've not heard in any of the wills till date. There were unsynchronized pinpricks on all the pages of the will, showing that the pages had been taken from different stacks. Now what happened over there was that Raja never had the habit of going to the registrar himself to get any documents registered. He had a lot of signed papers. Now when this will was examined, it had multiple pinpricks over there. Now if 9 pages of fresh papers, the will was to be typed and then to be pinned, there could be only 2 pinpricks or 3 or 4. There could not have been unsynchronized pinpricks. So the court came to this conclusion that it is very clear that Raja would not be collecting papers from different stacks to write a the will of his, a person who is has property worth 20,000 or 30,000 crore of rupees, he would have done it on fresh papers itself. These unsynchronized pinpricks showed that these papers were taken from different stacks and then the will written. So something which generally we do not consider, but something very interesting. Then it was mentioned on the will that it is a harograph will. Raja was highly educated. The correct word was holograph. A holograph will, as I have already stated earlier, is one which is written or typed by the testator himself. Now, Raja, as I already said, was highly educated. His education qualifications I would give down. There was no question. He had even got awards in English writing and essay writing in English. Harograph is no word. Now, the people who forged the will forgot that. That is why today I said that if you don't know good English and the person of whose will you are writing knows English, that you are in for trouble, friend. Because by writing harograph, there's no word. The court said it clearly meant that this is not written by the Raja. The correct word is holograph. Then something very interesting, as I told you that this will was exhibited in 2012 by Lalit Mohan Gupta, who was the CEO. But prior to that, the witness of the will was examined. Now, while filing his affidavit, he referred the will as Exhibit DW2/B even before it was exhibited. So the court says the connivance is writ large. The trustees, the executors, the witness, they all are hand in glove, because the will, which is yet to be exhibited, he already knows that what is the exhibit over there. So that was very, very important. Then the witness was questioned. He says he has no knowledge about the Raja, his litigations, his lifestyles, the people who know him, where he goes, whatever. He says, I have never dealt with any litigation. On the contrary, he also says that his ancestor and the ancestor of the Raja were inimical, quite inimical to each other. What the court held over here was that, of course, you would make a person as witness who's very close to you, who's well known to you, whom you know would stand by the will after you, and is there. Now, a person who knows nothing about the Raja, he's not done any of his litigation, was in fact because there was no question of having him as the attesting witness at all. So that eroded the entire credibility of the witness when he deposed this. Then what was discovered was that there was an advocate, R.S. Vaniwal, who was in fact one of the executors, and the witness was related to R.S. Vaniwal, having worked with him as an advocate for years. Plaintiff, in a very smart move, exhibited number of power of attorneys which were signed by both of them. The witness at the first instance refused that he knows R.S. Vaniwal. He says, I have no connection. When all these power of attorneys were exhibited, he agreed and admitted that yes, he had been working with R.S. Vaniwal. And what the court derived from this was, it was R.S. Vaniwal on whose instance he was made as the witness to derive benefit. Then there's something very interesting. These signatures of the witness were in different colors in the same will. On the front side of the will, the same witness signs in blue ink, and on the back he signs in the black ink. Now, if these witnesses have signed at the same time, there is no question of using different pens. So the court says a very valid suspicious circumstance. Now, it was also alleged by the daughter of the Maharaja, who was the chairman, that the rooms of Faridkot property were not open till 94. She was in Mashobra, where the Raja has a property. The court says it is improbable. You opened it, you knew everything about it. Wrong depositions. They only came to know about it when the income tax conducted a raid and saw wealth having been plundered. It was a very sorry state of affairs in the 94. I have discussed that further. When the income tax conducted a raid, they saw that everything in the Mahal of the Raja was plundered. There was nothing remaining. And even though the daughter was saying that they have not even opened the rooms till 94, the court says it was all false. Then, as I've already said, the court says there is no reason why the will should not have been disclosed to family members, the unmarried daughter, and why the wife was disinherited. Now, a Raja having such huge property and such a lavish lifestyle would leave such little amount, about 36,000 rupees per annum, to his wife and one house to stay, is totally inconceivable. It is not possible that he would not have given it. To the unmarried daughter, there is no provision, only 50,000 rupees for her marriage and some very, very minimum amount to sustain herself and one house to live. Over here, I must mention over here is that it was deliberately made that the unmarried daughter would stay away, though she was vice chairman, she was made to stay away from the Faridkot, and in the will it was provided that she'll have a house in somewhere in Delhi, Hyderabad, so that she does not interfere in the working of the trust, where the executors and the trustees could do whatever they want. So the court says it is impossible, because there was another provision made in the will that the unmarried daughter would only retain all these things if she got married in a royal family. The court says it is very strange that on one hand a provision condition is made that she must get married in a royal family, and there is no provision kept for her marriage. There is nothing. So what is the how will she get married in a royal family if she has no money? So they say it's a very suspicious circumstance. Then of course there was no provision made for the mother as well. So that is also another circumstance which was dealt by the court. Then, as I said above, Raja was highly educated, having studied at Aitchison College, Lahore. He got Godley Medal for essay writing in English language. He opened schools and used to meet a lot of politicians, bureaucrats. Now, why this was discussed was that in the earlier wills of 1950 and 52, there were no spelling errors at all. While in this 1982, there were more than 30 spelling errors. The court says it is highly unlikely that a Raja who was so well educated, has made earlier wills, trust deeds and everything, and is so well placed, would have committed so many spelling errors in the will. It's a very improbable thing, and that led to thinking that this was not made by the Raja at all. Then that aspect was also discussed, whereby it was held that the elder daughter was excluded from the will for the reason that she had married against their wishes. However, the Raja had made 3 trusts from the 1987 to 89, and all those trusts, the said daughter was the trustee, that is the one who was excluded. Now, the court says, if the Raja really wanted her to be out of it, then why should he have made her to be part of the trustee of these trusts which were established in 1987 to 89? So they said that it is absolutely unusual that the Raja would be letting her to be a trustee in the trusts, but excluding her from the will, giving nothing at all to her in the will. Then in these trusts also, which were established in the year 1987 to 89, the Raja had meticulously planned how the trust would function. But in this will, which is of 1982, there is absolutely no mention as to how the estate would be mentioned, how the income would be spent. There are only vague things that the property should be properly preserved and all those things, but nothing as such specified. You'd be surprised to know that, in fact, the 3 trusts which were made by the Raja from 1987 to 89, some of the trusts, the quantum was 5,000 rupees, 10,000 rupees and 25,000 rupees. But the Raja actually said that how the trust would work, how the money would be spent, everything was given. But on the other hand, the will, which is about his entire property, which is magnanimous, there is absolutely no disclosures. So as I said while making essentials, must not miss out on the essentials of the will. The essentials of the will were missed out. And then the court said that there are a lot of discrepancies and haste in the working of trust. I'll discuss that further when we come that how the court says so, that how the trust, because the trust never ever did work, because the Raja wanted that the trust must take care of all the properties, preserve them. There should be heritage of historical importance, but none of them. We all know the fort in Manimajra, that also belongs to the trust. It's in a dilapidated condition. The trust probably has not spent a single rupee till date on this. Even of the Faridkot, nothing at all was done. The court discussed that the trust formed 2 more trusts, transferring huge amounts which were not provided for in the will. The trustees, they were very smart. They knew that there are limitations in the will while functioning of this trust. They established 2 more trusts, which is not provided in the will. Huge amount of money, exceeding 100 crores, was transferred in those trusts, and money plundered actually. The legal advisors, they became the trustees in the new trusts. They could not have become in the original one over there, and the money spent as per their own whims and fancies. The trust failed to do anything according to the will. I've already discussed large amounts transferred to various persons. Even the advocates in the 1990s were paid 5 lakh of rupees for hearings of the cases, which were actually, otherwise they were drawing merely 4,000 rupees per month as salary. So that person who was drawing merely 4,000 rupees per month as salary was paid 5 lakhs for conducting a case. The court discussed that and saying that's not done. And I said that there was no provision for marriage of the youngest daughter, who ultimately died in penury. A very sad state of affairs, that there was no provision, merely a house and 24,000 rupees per annum. In fact, the eldest daughter and the youngest daughter, they were in very bad shape during the entire period because not much was provided for. Now, this all takes care of as to how the court, after taking into consideration all these suspicious circumstances, the voluminous evidence led by the parties to show that the will was not that of Raja, it's all forged and fabricated. The court minced absolutely no words. A very beautiful written judgment. It minced no words to state that this is a complete forgery conducted by the executors, by the trustees, and by one of the daughters of the Raja itself. One of the reasons given was that they had a fear, the daughter had a fear that if the rule of primogeniture comes into being, comes into play, then maybe the entire property goes to the eldest daughter. That is what was construed. To bypass that, this will was made, where a trust was established, everything transferred to this. The daughter became the chairman, the youngest daughter became the vice chairman. She was kept away from this, and how this happened. Now I'll just bring before you some of the very eye-opening facts which actually leaves one speechless, which finds mention in the judgments as to what the trust did. This is the eye-opening facts. You would understand what they did. They sold 4 aircrafts with license for rupees 1 lakh in 91. The court says the value of that licenses alone in 91 was much, much more than this. And the trust, by way of a resolution, sold these 4 aircrafts, which were valued in crores of rupees, for rupees 1 lakh. It is discussed that even a Fiat car in 91 was valued at rupees 1 lakh, and the trust sold this. There was no clause to sell the properties. A hotel site in Sector 17, Chandigarh, measuring 26 canals, was resolved to be sold at rupees 109 crores. Now, we all know Sector 17, the prime place, 26 canals for 109 crores. Those who have a little doubt about it, I can just tell you that one of the showrooms in the plaza itself cost something like 30 to 35 crores of rupees. And selling 26 canals for a 5-star hotel site at 109 crores, we could well imagine what the trust was up to. Then 103 acres of land valued at more than 200 crores, which is part of the airport, transferred to the trust by the trustees. They transferred to the other trust. The Raja had an airstrip and an airport in Faridkot, so that land was there. Huge land worth about 100 crores was also transferred to the other trust. 300 acres of land in Faridkot transferred, and sale proceeds transferred in another trust. All these properties were sold at absolutely throwaway prices, the trust, and even though there was no provision of selling them, the trustees intentionally did not make any inventory of goods and articles and stripped the valuables and even burnt many, which is admitted by the daughter of the testator. A very sad state of affairs is 20th October 1989, when the Raja died, the trust took over the entire property. They did not make any inventory of the articles. The Faridkot Palace in Faridkot was stripped of all the valuables, most of them burnt, and everything finished. When in 1994, the income tax raided, they said Raja owned expensive diamond gold jewelry, pearls, rubies, carpets, paintings, silver tea sets, lockers, safe vaults, but nothing was found there, not even a single ring. Just imagine that a Raja of Faridkot having innumerable valuables over there, and not a single thing was found. The trust and the daughter plundered everything. Not a single thing was found. The agricultural land was sold by the trust at rupees 23,000 per acre, airstrip at rupees 25,000 per acre, and residential house and residential area measuring 80 canals in Faridkot sold at 40,000 rupees per acre. The court says what should have been sold at the price of square yards has been sold at the price of per acre. The trust actually plundered everything. The fort in Manimajra and all properties are in shambles. The trust failed to do anything and in fact plundered the entire wealth. So that actually brings us to the end of this session. From what, if I sum up over here, is that what are the essentials of a will? When we started, I gave you all the essentials of the will, that these are all what you should have specified in the will. If you compare it with what the will, the advocates made it, or whosoever made it for the Raja, that was quite safe, quite good, registered, witnesses there examined. But when you go into the intricacies of it, there are so many aspects which the court can go into and learn and discover as to what is there, what is the intent of the testator, whether the will was actually on his free will or not, whether it was drawn by him or not. And probably this is one of those judgments which discovers such intricacies, including the pin marks also, to ultimately lead to the conclusion that this will was a forged and fabricated one. Ultimately, the court has held that the daughters would be entitled to equal shares along with the mother of Raja. So now it has to go as per the natural line of succession. So I would conclude my topic for today by only stating that when you draw a will, be very careful, because our drafting of a will has to be very professional, impeccable, without any mistakes, simple, no cuttings, no defaults, and with absolute clarity, so that the testator and the legal heirs who are the beneficiaries or the propounders may not face any difficulty. So thank you. I end my session over here.
Thank you so much. Thank you so much, Vishalji, for taking out time to discuss one of the most crucial topics of civil law, that is will. The essentials of will, what are the requirements of will, what care should be taken while drafting a will. Because this is a topic which consumes a great part of civil litigation. A very huge part of the civil litigation comes under the will. And the fault that generally comes in, I mean, the grounds of challenge is generally suspicious circumstances. Now, how to find out what circumstances are suspicious or not will obviously come out from the essentials of the will, to find out what has been missed out and what could have been the intention of the testator, what the testator has mentioned and what he failed to mention. Often a problem does arise. The testator does mention that I bequeath all my property after my death to my so and so heirs. The mention of the heirs will be there, but the description of the property will often not be there. He may fail to mention about the number of bank accounts he may have, or the FDs in which it may be invested, or the money invested in shares. What will happen in case there will be profit in shares? What will happen in case there is a loss in shares? So the details of the property is very important. Then of course the presence of witness at the time when the testator is signing the will is of utmost importance. In fact, the very meaning of witness is that he should witness the testator signing his will in his presence. And of course, if somebody is given something to learn vis-a-vis, when somebody witnesses that thing happening right in front of him, it makes a hell of a difference. And then of course, the nearly 550-page judgment which you have read out to us, which you have tabulated in such a beautiful manner. Not everybody could do that. This judgment, in fact, is for everybody to read and consume and read again. I think a very, very good civil lawyer, if anybody wants to become, must read this judgment. There's so much to learn from this only. And you by now must have become a very sharp lawyer. We are yet to become when we read it.
I learned a lot, Asim, while reading this judgment, and such aspects which, at least in my 16 years of law, I had never heard of pinpricks on the will also being
Certainly.
examined. To that extent, the court has gone. So a very beautiful, and I must say that the judgment has been written very beautifully and indexed very beautifully. From the index itself, you come to know that where you must go to the judgment to read a particular aspect to it. And I must tell you that this judgment is multifaceted. I have only dealt with the will. It deals with the rule of primogeniture also, and many other things, succession, the Faridkot Act of 1948. It deals with everything, all those in detail, and the CPC delay in challenging the wills. Everything is there. So very beautiful judgment, I must say that. Any
we
questions?
obviously cannot lose sight of the fact that yes, the questions are open. In fact, I was just wanting to say that we cannot lose sight of the fact that the judgment is written by the judge who has written the judgment is a master of civil law himself.
Absolutely.
He understands it most beautifully, and he has taken great pains to write down such a detailed judgment. And if anybody sees that it is a judgment, the judgment itself running into 550 pages, one must wonder that the RSA must have been filed 20 years ago and must have been lingering on. No, the RSA was filed in
RSAs of 2018. Something very
2018
interesting.
only.
Yes.
In just 2 years, it has been disposed of by the High Court.
We give all the credit to the honorable judge who took it up for
Yes.
day-to-day hearing. Every day it was
Yes.
argued for over 3 months. And from every day after 1:45, it used to start till 4 o'clock, spread over 3 to 4 months. So we must credit it
The
to the
lawyers
honorable
arguing before the honorable judge themselves are legal luminaries. To take down their arguments, to remember word by word what they've argued, to make a note of everything, and then to delineate it in the judgment itself is great.
To my knowledge, the record ran into about 20,000 pages. I wonder how he read it and summed it up.
Must have been not less than that.
It was that voluminous. It was that voluminous.
So now we are open to any questions that we have. If everybody permits, I have one small question myself.
Yeah, please.
Just while going through the Indian Succession Act, I mean, this is something that I'm pretty sure that most of the lawyers would not have even heard. We only heard will, but we've not heard the types of will. The two types mentioned from Chapter 3 to Chapter 4 of the Indian Succession Act are the privileged will and unprivileged will.
Unprivileged will, that's right.
Could you throw some light on that, please?
The privileged will is generally qua the sailors, the army men and all who are out there who may not be present. So that is the exception which has been made, that in case they are not there, they make a will, they can, the proper procedure is given, because I had really emphasized time and again to state that the testator must sign in presence of witnesses, at the time testator must be registered. So the privileged wills is that they say that these people are in field. There may be a time which arises that they cannot execute the will in the manner it should be. So that that procedure is given, that how a privileged will must be dealt with. And unprivileged will is of course qua the normal people like we are, and I've already reproduced it in my compilation itself, that the unprivileged will, how it has to be executed and registered.
Right. So we have one question coming from Laliji. He says, did the court grant consequential relief?
No, it did not.
Aside all sale deeds by the trust?
That was beyond the scope. I wish it would have. But it was probably beyond, because that was not the relief prayed for by the plaintiff. Had they prayed for, things would have been pretty different, and you would have had about 100 cases. Some of us might have also been engaged, because so much of property has been sold off. A lot of people would have been challenging that.
So
any other questions do we have?
Yes, sir.
Sarthak, please.
So, is it advisable to make a will in case you want the property to devolve by rules of natural succession?
You may, because there are certain things that you can devise. I'll tell you an example. I have done it also. There is a couple over here. They have only 2 daughters. They don't have a son. Now they say ki, as per natural succession, it has to go 50-50. Now, why they made a will and why I made a will for them was, they say that when this property goes 50-50, there will always be a dispute. One may want to sell it, the other may not want to sell it. Then there is a litigation. You have to file a suit for partition, and it goes on long and on. So they clarified that. Now they say that this property, this will go 50-50. One of them may want to sell it. She'll give an option. So you just lay out the procedure, how it will go, how it is to be distributed, and in case there is a dispute, how it will resolve. So those issues can also be a part of that will, even if it has to go per natural line of succession. So that clarity can be drawn, which definitely helps you to avoid litigation. Suit for partition, continues for years and years. Then preliminary decree, then the final decree, it goes for 20 years. Now, if that specifications are there in the will, probably you just have to get that will executed. So yes, of course, even if it is as per natural succession, it is definitely advisable to execute a will.
Okay. Lalipaji has another question to us. He is asking how the shares have been divided now as per the judgment.
Now the shares have gone as per, it is in fact 1/4 each to 3 daughters and the mother. The daughter which has died, it will go as per her line of succession, and the mother, she's also died, so as per that line of succession. So now as per the Succession Act, in the Succession Act, it will go as per that.
It also says the brother's son will also get a share through this.
Because the mother's share would come to the
Yes,
brother, na?
yes,
So
yes,
I
yes.
said the
So
mother's share
through
would
her,
go
through her.
through her.
he
It would
will
go.
get
Yes,
something. He will get.
Now the brother of the Raja has also died. He has
Yes, yes.
his grandson is there in Chandigarh sector 9 itself.
Okay.
Yes, yes.
Also, just a trivia question.
Yes, yeah.
Is this the same Rajkumari Amrit Kaur as the first health minister of India?
No. She's not the one.
Okay. Because
She's
she was
not
also daughter of some princely state, if I'm not wrong.
Not to my knowledge, at least. Because this has not come. And no, it can't be. I'll tell you why.
Yes,
I'll answer your question. It is somewhat part of the judgment, so I can answer it, though I have a lot of knowledge about that also from my personal knowledge.
Okay.
Two of the Rajkumaris have also executed assignment deeds. As I told you, they were living in penury. They had no money. So they have executed assignment deeds, cost some of their share to many people. They used to take money from them and assign that if we get a share, then you would say, had she been the health minister, she probably would not have required. She's also executed assignment deeds.
So
that finds mention in the judgment as well.
I was just checking. She was the daughter of the Raja of Kapurthala, not
Faridkot. That's right. That's how I told you. I could derive from that. I know some of the assignees. They are very happy.
Okay.
They're
Who
very happy.
Who were the advocates in this case?
Mr. Khera was for the plaintiff. Mr. Vishal Aggarwal was for the trust. And then for the Mr. Vivek Bhandari was for the other brother. And then some more advocates.
I think there were 3 appeals. All of them were appellants and respondents in each other's cases.
In fact, Mr. Kheda was looking throughout the case, even in trial court as well.
In trial court, yes. So he was for the. I tell you, I can just repeat this aspect. If you read the plate, you'll just throw it in the bin. The evidence proved the case. Beautiful evidence, because it's not the fault of the lawyer or the daughter that the plaintiff had. She had no details. The will was never shown to her. Unless you see the original will, you can't. It was in 2012 when the original will was exhibited. The handwriting expert examined and discovered what was wrong. It was thereafter everything came on record. Before that, no one knew what is wrong with the will.
So if it's a registered document, isn't it open to the public to view?
But unless you get the original will, how do you examine it?
No, this is just a. I don't know if
this aspect. It should be, but this has not been discussed. But ultimately, they said that she wanted the original will. The original will, when it came to the court, there was another aspect to it also. I'll tell you why. Probably one of those delays also helped it. But still, I would say it should have come earlier. There arose a dispute qua the valuation of the property and the court fee. That in itself continued for years and went up to the Honorable Supreme Court. Ultimately, a court fee was adjudicated upon, and that was paid by the plaintiff. But that too, because the jewelry is invaluable. Even the jewelry which is lying now in the lockers, it has still not been valued. It would run into thousands of crores.
Yeah, you had something.
Yes,
sir. Please, sir.
Now, as far as the question was that whether anyone could obtain the copy of the will from the office of sub-registrar, is that any heir can get the copy of the will by producing the certificate of death of the testator and to show that he is related to the testator. Only the relatives are entitled to get a copy of the will. Third person is not.
So under RTA, is it possible?
No.
RTA will not give a personal information. RTA has a clause of personal information being not disclosed.
Then they have to ask from the person from.
That is third party, it will be denied.
Yes. And secondly, in section 62 of the Registration Act, an amendment has been made by the Punjab in 1961 that whenever a document is got registered in another language than Punjabi, then a Punjabi translation has to be annexed with the document. One. Secondly, as far as Mr. Vishal had pointed out, that it was not a carbon copy of the original will, which was registered with the sub-registrar. The practice is that original will is typed, then another copy of the will or the document is typed on which it is written copy, nakal. And that copy is pasted in the record of the sub-registrar along with the translated copy. So translation of the copy of a document which is not in Punjabi language, that has to be produced at the time of registration of the document.
In this case, these two copies which were typed separately, there were glaring differences.
No, there may be. There may be.
No, what I intend to say was, the court held that Maharaja Faridkot would not have tolerated this, and such a learned man would not have tolerated this.
So sometimes he may be old. He may not be able to point out all those things.
He was only 67, hale and hearty, and pretty good. That was also
why he died so early?
Son. After his son died, he lost heart. 81, his son died. 82, this will is alleged. Sir, in fact, ultimately what it has been held at after this discussion comes to an end. I can't come on record. I'll tell you how this will came into being. The court has given a finding. This will was never made by Raja. It wasn't made by him. This is the papers used. Hanji?
All the signatures at 33 points.
Yes. He had the habit of signing vacant, empty papers, and these papers were taken from different stacks. वहां से एक पेपर निकालिए, वहां से निकालिए और करके वो इकट्ठे करके वो ऐसे किया. Very beautifully discussed in the judgment. After this discussion, I'll tell you how it was made. I know that also.
No.
And when it was made.
That may be off the record, not on the record.
Off the record बताऊंगा आपको कैसे. I know that.
Secondly, the question is that sub-registrar can come to the house of a person to register the will. There is a provision in the Registration Act.
Absolutely. अब उसमें ये कहा गया. That's right. They say कि whenever all documents of the Raja were executed, they were all executed in the office of registrar. Never after 5 p.m. All during office hours. Why this exception was there? And it was coupled with the facts कि why pages number 27 to 61 were torn. That created all the issue. That point could have been overlooked, saying कि चलो ठीक है, sub registrar घर आ रहा है, he's a Raja, as it is he could have called. But yes, all these circumstances combined together led to this inference कि this was there.
But as far as the maintenance of record is concerned, that is not in the hand of anybody. It is the office of the sub-registrar or the...
True, but then it was showing that the forgery was writ large. Sir, the value is... Signatures
were genuine.
Of that, even the plaintiff never said. I am saying that it was blank signed papers which have been used, but will has been typed over it. Sir, you are mute.
Now, hello.
Hanji sir.
Now the question is that even if a document is written on a blank signed paper, even then it can amount to forgery.
Of course. The court has given a finding. If it is a forged document, then it has to be set aside. It has been set aside. The will has been declared to be invalid. Set aside.
Now the question is that all the acts done by the trust, which was created under the will, they also get set aside.
Have to go, unfortunately, in the plate that relief has not been sought for. Jagjot had asked that question. In fact, in that it should have been said that so much so the court has observed there was a stay by the court and still the trust continued to sell the properties. Now, of course, they'll revert back, but litigation would start now.
Then litigation has to be there, but the property will revert back because the trust had no power.
Has to. The will itself did not give, even the will did not give the power to the trust to sell it. The will has gone, of course. Yes.
Those alienations are null and void.
There's a lot of litigation which is going to rise out of it. Lot of litigation is going to rise out.
Now the entire property will go by natural succession.
Has to go by. The court has held this. Natural succession.
Yes.
Do we have any other questions?
Anything else?
Vishal,
Haji.
can I ask a question?
Yeah, sure.
There's an issue. I am a tester. Somebody is a tester who drafts his will in English, and it's a mandatory provision, as the Mr. Jindal said, it has to be translated in Punjabi. Then suppose I am the tester of the will. I do not know the Punjabi. So what's the provision? how can I know that what is the spectra of
I said so in my this thing also, that
Read over and
read over and explained. Whether you know English or whether you know Punjabi, whatever will you draw, it has to be said, read over and explained in very clear terms. I'll share some wills with you. There are some very mandatory things which
I'm
must
in a
be.
hypothetical situation. Suppose they read over and explain me the version which is written in English. If I don't know that language, is it possible? So is there any provision that I would like to have registered only English will, not that the Punjabi will? Is there
that Mr. Jindal can tell, because amendment he knows. I don't know about this amendment.
Yeah, because I was asking this question, why it is mandatory to register a will in Punjabi? That document has been translated in Punjabi.
Mr. Piyush, the thing is that as far as Punjab is concerned, Punjabi is the official language. As far as Haryana is concerned, Hindi is the official language in which the documents are being registered. All the sale deeds and all of the documents are being registered in Punjabi in Punjab. So that is mandatory. Now, one thing I may point out to you is that when we record the evidence of the witness, we write at the end R, O, and AC. Do we read the entire deposition to the witness and say that, okay, you accept it or not? And if you read that cross-examination to him, he will say that I had never said so. All the admissions and everything which he has made
in this matter itself,
during the course of examination, that will go to air.
In this matter itself, the Rajkumari presented her affidavit in examination in chief in the court, and she had not read it. It has been proved on record. And they say it was like this. It has been proved on record that it was typed by someone else, and Jesus signed it. It has been clearly stated in the judgment that she's one of the conspirators to get it done.
And as far as the statement of Lalit Mohan Gupta is concerned, wherein they have said that he had exhibited the document even before the affidavit was produced on the record. This is also not normal practice. Yes. Because we exhibit the documents at our...
No, sir. It says the witness in his affidavit had stated that the will is exhibited as exhibit so and so. The will had not been exhibited then. It was exhibited later on by Lalit Mohan Gupta. Lalit Mohan Gupta had not been examined by then. So he says, how did he know that it is going to be exhibited as exhibit DW2 over B? Court says they are all in connivance.
No, in whose affidavit it was said so?
In the attesting witness. He did not exhibit the will.
Baljinder Singh, sir.
He did no, not Baljinder. His name is Harjinder Singh or something like that.
Harjinder Singh. But Lalit Mohan Gupta was not a attesting witness.
No. He was the CEO of the trust. He produced the original will in 2012.
He was an advocate or?
He was an advocate.
He was junior to us then. He is practicing on the income tax side.
Yes.
He was junior to us.